Good evening, ladies and gentlemen. My name is Joseph Malcarney. I am the Town of Clinton Zoning Board of Appeals Chairman, and I'm calling this meeting to order at approximately 6:33 p.m. And I would ask that my colleagues introduce themselves, starting at my right.
Ron Mostello.
Daniel Vonderbrink.
John Calogero.
Charlie Canham.
Russ Tompkins.
On the agenda for this evening, we have an area variance application for 4 Old Bull's Head Farm, LLC, and an interpretation. Have all the adjoining property owners been notified and fees paid?
Yes.
Okay, the meeting is being recorded and is being broadcast momentarily.
And we're having a difficult issue.
Yeah, as soon as that happens. So yeah, we'll start with the 4 Old Bull's Head Road Farm, LLC, if you want to come forward and have a seat. And if you could, yeah.
How you
introduce
doing?
yourself and kind of tell us.
I did.
She did. So if you can kind of explain why you're here and how we can help you.
So I'm John Paul Avital, owner of 4 Old Bull's Head Farm, the old Meserix farm on Old Bull's Head Road. I purchased the farm for my family, and we are in the process of trying to get it back to life.
Great, great. And what can we do to help you get that back to life?
A variance for an accessory structure that is too close to the road.
Okay, great. Ron?
Okay. So, as Mr. Avatal states, there is an existing structure there that will be used, for the time being at least, as a primary dwelling. Correct me if I'm wrong, but I believe the structure had existing bathrooms, bedrooms, septic systems, etc.
Correct.
Okay.
Well,
And a well. Okay. The issue at hand is that the front yard setback is 11 feet as opposed to the required 100 feet. So the applicant is seeking a variance for that setback reduction to bring that building into compliance. The property is in Land Conservancy. The owner has met with the staff of the Land Conservancy, and they have approved that, not only that structure, but possible future primary dwellings down the road, 3 to 5 years possibly, I believe you said, right?
correct.
So the Planning Board and the Land Conservancy Board are in agreement that that might proceed pending our discussion. What I struggled with, or wrestled with, I guess, is I wondered if in fact a variance was necessary here. Since the structure dates to the early 1950s, predates zoning, and we have evidence that it was a dwelling, is a variance necessary? I drafted a motion pending our possible conclusion that yes, it might be necessary. Planning Board feels that it's necessary, or I should say they voted unanimously to approve the setback reduction. So I guess our discussion is whether or not a variance is necessary. If so, I'll present the rest of the information and we can proceed as such.
Well, Jeff, do you have any comments?
Russ and I spoke briefly ahead of the meeting, and we have, subsequent to the original application being submitted, received these photos that show that when John purchased the property, these other facilities were in place. However, there's no town or county record of that change of use ever happening in a legal way. And so I think as you explore that discussion, one of the requirements of a non-conforming use is that it's a legal non-conforming use at the time. So if, I think in looking at the building permit application when it first came in, if we had seen more evidence that there was a record of that change, then I would agree and not have sent it for an area variance, but I think it's certainly worth a discussion.
Okay, all right. further discussion for
Well,
the?
do you have a preference? You know, the benefit of acquiring the variance is just in terms of future and things like title insurance and any question that might arise in the future. So you know, might make your life simpler if you don't have to get a variance, but there might be benefit to getting one. Do you have a preference?
I don't have enough knowledge on that to make a decision.
Eventually it's gonna do
And
a bigger house too, so.
neither do I. That's why I wanted to present it to my colleagues here. My concern was if there's a variance on this structure and he applies for a permit for a primary dwelling, a permanent primary dwelling down the road, is he sort of handcuffed as a result of this variance?
Is he handcuffed?
It's an interesting point, because it's, that structure would have to go back to being an accessory structure.
I
Yes.
think it's gonna be an ADU.
It would be an ADU if you built a permanent larger dwelling, yes.
Right. And then,
Not unless he's gonna remove all the kitchens and everything.
But would that then trigger a requirement for, I mean, a change in use from principal to accessory?
right.
Yeah, this is a,
I thought this was simple. It's not.
yeah.
If I may, so our schedule of use regulations doesn't differentiate between types of residential uses. It's one section for residential use. So if you grant an area variance for this structure as a residential use, then it could be principal or accessory, either one, whatever else is allowed in the zoning district.
I'll just speak off the top of my head. If you go up that road, almost every dwelling along it does not meet the setbacks. Okay, the big house on the left doesn't, the little house on the right doesn't, the next house before that one doesn't. Even the big house in the back, I don't think any of them meet the setback requirements. They all existed prior to zoning. The only thing I can see that we're doing this way is that we are kind of making it acknowledge that it's legal and there's not a problem with it. I had the same problem in my house, which is right on the corner of Shellsville, when I went to do a lot line adjustment. My house existed before the road did down there. And this is some years ago, said I needed a variance for my house that existed probably 100 years before zoning came in. So I got a variance for it, and now it's kind of, how can I say, it made it nice. So I think that by giving this variance for the 11-foot, it just potentially prevents any problem in the future saying, well, you know, what do we got here? Because like I say, all those houses along there are within the setbacks.
Right.
And if he goes to do something in the future, that somebody can't come up and say, well, wait a minute, you got this thing here. I would think that because it predated zoning, we should have something in the law that just says, okay, it's legal. It's like a grandfathered lot, you know? But I can't see a harm of granting it. I think it would maybe be like an insurance policy if we grant the variance.
Yeah, and I agree, as long as, Jeff confirmed that it would not conflict with any, larger primary dwelling in the future. And, I'm sure that'll show up in the minutes for the homeowner's peace of mind in the future if he needs it, so, okay.
So your concern is that by granting the variance, it would somehow limit what they could do in the future?
Yes.
With the applicant? No, it's a valid concern. And Jeff, what I'm hearing you say is, no, that would not be the case?
If the resolution was written such that the variance was granted for a principal dwelling unit to be 11 feet from the edge of the setback, then that would. But if it's a residential structure, then it doesn't.
No, just to clarify, the draft motion does specify principal dwelling unit, but when it becomes an ADU,
So that's, if we just change that to just that dwelling unit.
take that out of the draft
Yeah,
motion.
take
Gotcha,
principal
okay.
out.
Okay.
Yep.
And if I may add something, the new residence that we would be looking to build in the near future would meet all the setbacks, today's code setbacks.
Perfect.
so.
Yeah, just the key is that if that becomes the principal, then this becomes an
Correct, and
ADU,
that's what I'm worried
and
about,
if-
too.
and if we tie it into principal, then it becomes an issue, but if we just say a dwelling unit, then it doesn't become an issue.
Correct.
And you have more than enough acreage to qualify for an accessory dwelling unit on this parcel. so.
So we would be changing principal building in this to dwelling unit? Is that what we?
Yeah, I made the change on the draft to say, make an existing dwelling unit with a setback of 11 feet from the required 100 feet.
Great. All right, any other discussion from the board? I'd like to make a motion to open the public hearing. Is there a second? Second. All in favor?
Aye.
All right,
So moved. At this time, we'd like to hear comments from the public. Yeah, if you could be willing to state your name and your address and.
Sure. My name is Kathleen Blake. I'm here with my husband Jeff Silverman.
Uh-huh.
We own the property at 132 Old Bull's Head Road, and this gentleman is correct. Our house is 10 feet from the road. It's just the way it was. It was a very old structure. And we just wanted to appear tonight to say that we completely support what John Paul has done in the neighborhood. It's a great improvement, and the old structure that was there was actually on the road. So the 11-foot setback is an improvement as far as we're concerned. So, did you want to add anything?
Yeah, I was going to say the same. We're here to show support.
Great.
It's been great having John Paul and his family in the neighborhood. We walk ourselves and our dog up and down the street all the time, and for years, there was a lot of blight, there was a lot of eyesore, and to see what he's done from a beautification perspective, it's been a welcome change, and we're fully in support of granting a variance of the variances.
Great, thank you very much for sharing.
Thank you.
Appreciate
Thank
that. Okay. Any other comments from the public at this time?
Good evening. I'm Vincent Tian. My wife Johanna Treacle and I live at 194 Old Bull's Head Road, and we've lived there for 42 years. We lived when the chicken farm was in its full flower. Our very good neighbors, the Meseriches, had it and ran it. It was not beautiful. It was efficient, but sadly, after Bob left us, it was abandoned. And what the Avitals have done in our neighborhood is nothing short of remarkable. We do not miss the former chicken slaughterhouse. The new house could be viewed as an improvement. We're very happy to see it, and to the extent that the board has to exercise any discretion to assist the Avitals with something that they didn't really intend to live in a chicken slaughterhouse, that I would completely support granting such variances and requirements as the Avitals would need.
Great, thank you. Yeah, appreciate that.
Thank you.
Yep. And
before Meserich, it was Katz Chicken Farm, K-A-T-Z. Before Meserich, it was Katz Chicken Farm. I've been a native here for 80 years.
Maybe I can talk to you about the history of chickens here.
Yeah.
Thank you, Vincent.
any other comments from the public at this time? All right. I'd like to make a motion to close the public hearing.
Second.
All in favor?
Aye.
So moved. Further discussion from the board, if any? John, anything?
Just a question, I'm not even sure why I'm asking this, but are there any ag exemptions on the property at the present time?
I would have to look into that. I know the property is zoned in the agriculture,
Right.
but I would have to speak to the assessors and also Cornell on 44 in Millbrook. I'm almost positive there was prior to me purchasing the property, but I have to transfer the ag exemption. I do ag work, and I grew up on a farm in East Fishkill, so I have ag in my background.
Right.
I'm not sure if I can transfer that from farm to farm. I'm still new on that and looking into that.
Great.
Can you answer that one, Jim?
I can try.
Okay.
So it is currently in the agricultural district. There's a difference between being in an agricultural district and being part of the assessment reduction program. Being in the agricultural district relies on, and it's intended for protection of farmlands and the potential for farming. It doesn't require that a farm operation be on the property. To be part of the assessment reduction program, you have to be already in, actually, you don't have to be in the ag district, but you have to have 7 acres of production, $10,000 in annual gross sales value or more, and be a legitimate farm operation, and file with the assessor. And that's a different program. So if the property is currently receiving an assessment reduction, that would be up to the assessor whether or not it continues to qualify. But it does, from my knowledge of ag markets, continue to qualify as an agricultural district.
One other question, am I correct, there's a Duchess Land Conservancy easement on the property?
Yes.
And so I can just encourage you to talk to them carefully anytime you plan something. I've served on land trust boards for 30 years, and people unknowingly run afoul of easements, and it causes a lot of hassle. If the building is 3 feet over the line of the building envelope allowed in the easement, all of a sudden, it's really hard to change the easement, and so often people end up moving a building 3 feet. You don't want to do that, so just, they're good people there, just talk to them.
I have been working very closely with them. In fact, they were like the first ones that I reached out to prior to purchasing the property.
Great, thank you. Ron?
Okay.
Your motion.
Yeah, I won't go through the planning board because, quite frankly, my motion basically mirrors the planning board decision, so. I hereby motion that the Town of Clinton Zoning Board of Appeals grant the requested area variance to Section 250, Attachment 2, bulk regulations to make an existing dwelling unit with a setback of 11 feet from the required 100-foot front yard setback for a property owned by John Avital, located at 101 through 166 Old Bull's Head Road in the Town of Clinton, tax grid number ending in 964491 in the AR5A zoning district. The applicant is requesting an area variance to allow an 11-foot front yard setback for an existing structure that is now the principal building on the property from the 100 feet minimal front yard setback. Whereas the property is 23 acres, the property is not within a CEA, the property is not within the scenic or historical overlay district, the property is within the ridgeline protection overlay, the property is in an ag district. The variance is substantial, but should not necessarily preclude the granting of the area variance as the structure already exists in its nonconformity. The proposed variance will not have an adverse effect or impact on the physical or environmental conditions of the neighborhood, as residential dwelling units are allowed in this zoning district and the building is pre-existing. The benefits sought by the applicant can be achieved by some other method, but would require either moving and/or construction of a new structure. The alleged difficulty is self-created in that the benefit can be achieved by some other method, but should not necessarily preclude the granting of the area variance. The application fees have been paid, and then the following conditions were also placed on the variance. Number one, that the health department approval is granted with final septic and well approvals from Dutchess County Department of Health, and should be required before issuance of any certificate of occupancy. Number two, no external alteration that increases the nonconformity or any future expansion must comply with zoning setbacks and require separate variances. And finally, record restriction. A covenant recorded in the county clerk's office stating that the variance applies only to the existing structure.
Second for discussion?
Second.
Okay, discussion? We just make point 11 that the area variance is a type 2 action under secret.
Oh, yes.
Requires no further review.
John, I did find an answer to your question. The property does not currently receive an ag assessment reduction.
Okay. Thank you. Ron, going back to the 11-foot, how did you word that last piece?
In the beginning of the draft motion, John?
Well, you just, the setback, we were talking about the setback.
Make an existing dwelling unit with a setback of 11 feet from the required 100-foot front yard setback.
Okay, and the understanding is that that is just for the building, the setback. So you can't put other things in the 11 feet. Okay, another part of the property.
Understood.
Do you mean storage of any other things, or like a front deck
Yeah,
or something like that?
storage.
You wanna make that a condition? We typically do that in side yard and back,
Right.
but I thought that this one was so small, there really isn't room to do that there.
Just don't wanna see him have trouble in the future, but just so he understands it, that's all. It's really important to me.
Any other discussion or comments? Okay. Russ, your vote?
Aye.
Aye.
Aye. Aye.
Aye.
Aye. So your
Thank you.
variance has been
Thank you,
granted.
Chairman. Thank you, board members.
Yes, you're welcome.
Good luck.
Did you, put all the conditions, the same conditions on the plan board?
Same. I'll send you the final copy.
Anybody has to go in the bathroom before the long meeting? It's up to
Very
you.
good. Yeah, we can always.
Can you just make an announcement saying that there's a technical issue on TV, but it's on YouTube?
Okay, so if you heard that, there's a technical issue with the TV. It is on YouTube,
Not on,
but not
Local
on.
channel.
But
the
we
local
can't see
channel.
ourselves on.
Yeah.
it is, it's working on there. I went there.
Yeah, sometimes we can see ourselves, up there to monitor. Okay, so we're moving on to the interpretation, and with that, I'll turn the time over to Charlie.
Yeah, at its meeting on August, I'm going to read a statement. There are a lot of lawyers in the room. I want to make sure I don't misstate or forget to say something. At its
Oh,
meeting.
I'm sorry, just before we start, I neglected to introduce Shane Egan, who's the town attorney, who's kind of sitting back here.
Yes, I'm sorry. We're here to address a request from the planning board for an interpretation with regard to the CECNY application for a conference center on a parcel here in the town. And so at its meeting on August 5th, the planning board requested a determination and interpretation by the zoning board on the subject of whether the planning board can proceed with review of the application by CECNY Land Holdings LLC for development of an expanded conference center at the property it owns on the western edge of the town of Clinton. As I'm sure all of you here remember, this project has been controversial, and in response to an appeal by a group of concerned residents, the ZBA was asked to review whether the proposed development was consistent with the town's zoning code. After a number of meetings, at our meeting on June 4th of 2024, the ZBA passed unanimously a resolution that concluded that the proposed development did in fact meet the definition of a conference center under town code. However, a separate section of town code, section 250-24, prohibits issuance of a building permit for any structure unless the lot has legal access to a public street or highway. Now, access to the CECNY parcel in the town of Clinton is from Route 9G, but has to pass through a small parcel located in the town of Hyde Park. And again, as I'm sure you're all aware, while the pre-existing conference center on the Clinton parcel had a pre-existing access road through the Hyde Park parcel, the current zoning of that Hyde Park parcel did not allow commercial development. As a result, the Hyde Park zoning administrator and subsequently affirmed by the Hyde Park ZBA, determined that CECNY could not construct the new road access they desired, including construction of a necessary second driveway for emergency access. Thus, at the time of our June 2024 resolution, the parcel did not have the required legal road access required by town code. As a result, our resolution, June of 24, concluded that, and I'll quote here, until such time as the denials issued by the town of Hyde Park zoning administrator, which prevent the property from having access to a public highway, are reversed pursuant, and here are the words, to a final non-appealable decision, the amended application is not in conformity with the town code and cannot proceed to the planning board for review, end of quote. Now again, as I'm sure you're all aware, subsequent to our June 2024 decision, the Hyde Park Town Board passed a local law that created a legal presumption in favor of allowing access across land in Hyde Park to serve uses located and permitted in neighboring municipalities, even if such uses were not permitted in Hyde Park. the local law also effectively reversed the decisions of the Hyde Park ZBA and zoning administrator, which denied access across the parcel. Soon after the passage of the Hyde Park local law, CEC NY settled their Article 78 proceeding against the towns of Hyde Park and Clinton. As part of that settlement, the three parties, the Clinton Town Board, the Hyde Park Town Board, and CEC NY, agreed that the Hyde Park local law now allowed access across the Hyde Park parcel to serve a legally permitted use, i.e. the conference center in Clinton. Also, as part of that settlement, the three parties agreed that their stipulation constituted a non-appealable decision, as that term was used in our June 2024 resolution. Thereafter, a separate Article 78 proceeding commenced against this board was discontinued by CECNY. Very recently, CECNY submitted an amended site plan to the Clinton Planning Board and asked the board to resume its review of the application. The planning board then was copied on a letter to Supervisor Witten from Attorney Warren Raplansky, representing concerned citizens, contending that the requirements in our 2024 resolution for a final non-appealable decision allowing road access had not been met. The planning board also received correspondence from attorneys representing CECNY, contending that the requirements that there be a final non-appealable decision reversing the Hyde Park denials had in fact been met. Given all of that, the planning board concluded at their meeting earlier this month that they wanted to know whether the CECNY application is stayed in light of the SOARD stipulation of the settlement. I'm sure that all of us on the ZBA appreciate the planning board's deference to us on this matter, and that they have given us the opportunity to revisit this issue. I would just like to point out that there are 4 lawyers on the planning board. They also had very detailed letters from attorneys on both sides of the issue. There are no lawyers on this board, although one of our esteemed colleagues here on my left was a town justice for many years. Nonetheless, we will do our best to respond to the planning board's request. Now, before we open to the public hearing, I want to make one personal comment about public input on this issue. And that comment reflects what I've heard Supervisor Mike Witten say about this whole matter. The town board, the planning board, and the ZBA are all charged with following and applying town law. The town board counts on us, the ZBA, to interpret and apply zoning law fairly and impartially. So our resolution of June 2024 dealt with whether the proposed project was consistent with town zoning code. Our personal feelings about the pros and cons of that development for the town were completely irrelevant. The same applies to the stipulation made by the town board in the settlement of the Article 78 proceeding brought by CECNY. Now, Arlene has received many letters submitted to the town website regarding the matter before us tonight. The majority of them have focused on whether the writer supported or opposed the development. We're happy to hear from any and all public input. That's why we're here tonight. But the issue strictly before us tonight is very narrow. Have the Hyde Park denials been reversed pursuant to a final non-appealable decision as stated in our June 2024 determination? If it has been, then the planning board can proceed with its review of the amended site plan. So before opening the public hearing, I'd like to see if any other members of the zoning board want to have comments at this point.
And maybe just, to give you an idea, these sheets of paper are all double-sided, so we probably have maybe 30 to 40, email communications, both for and against this. So we have seen them. We appreciate, again, you submitting your comments, your feelings. And again, going back to what Charlie said, our job and task here is to provide an impartial, unbiased decision about has this requirement been met or not. So, thank you. If there's any other comments? Okay.
So if not, I'd like to make a motion to open the public hearing.
Do we have a second?
Public hearing is
Oh,
Yeah.
oh,
So,
from the,
no, I think we,
From when?
we closed it.
No, that's separate. This is a separate issue.
Yeah, we have to open it. Yeah.
So-
I make a motion to open the public hearing.
second? Second? All in favor?
Aye.
So moved. Okay. Comments from the federal?
I get to
Yes.
turn off my mic. You all get.
Hi, good evening, everyone. Nice to see you again a year later. I'm Victoria Polidoro from Rodenhouse Shaw Polidoro in Rhinebeck. This is my co-counsel, and more colorful attorney, Mr. Stanger. He'll be addressing you later tonight. Mr. Canham's summary just took out the first few paragraphs of my overview. It was a very good overview. So I'm just going to get to the meat of it, which is that you're being asked to confirm whether the condition has been satisfied, and it has. Zoning, being in derogation of the common law, must be strictly construed against the landowner, right? The law favors the free use of people's property. Zoning restricts the use of property. Your condition, which restricts the free use of property, must also be strictly construed. If you look at your condition, which was read by Mr. Canham earlier, it refers to the Hyde Park denials. This is a defined term within your document. If you go to page 2 of your findings, it's defined specifically as 2 documents, the December 21st, 2023 and February 9th, 2024 determinations of the Hyde Park zoning administrator. Those were the determinations referenced in your condition. It wasn't a broad condition. It didn't say, every possible appeal brought by the neighbors, every possible thing must be determined. It said those 2 documents must be overturned. So now we are in a situation where those Hyde Park denials, as defined in your resolution, have been explicitly overturned by Hyde Park Town Law 1 of 2025. This local law states that, quote, any determination made or action taken by either an administrative board or an administrative officer prior to the adoption of this local law, which does not comply with this section, shall be deemed null and void and without effect. So I know you're not a board of lawyers, but null and void and without effect is legalese for reversed. So Hyde Park denials, as you define them, have now been reversed. That's it. I mean, it's a very simple and narrow issue before you. If you want to put this condition in the context of your review, at the time, sorry, there's feedback. At the time of your review, you had the 2 determinations from the zoning administrator in front of you. You weren't sure how things were going to turn out. You wanted to protect the board's decision. You put in the non-appealable requirement. When local law 1 was passed, those denials went away and there's nothing left to appeal. Although the opposition has challenged the local law, that's not an appeal. That's a challenge. You don't appeal a local law. Your words in your resolution should not be broadly construed to consider that an appeal. That is a challenge to a local law, and I don't know if you know this, but local laws are presumed valid. They're full force and effect unless and until a court determines otherwise. So right now, everyone is bound by a local law which says we have access to the property. It would moot your determination if your determination wasn't already so tightly written. If your determination had just said until there's access, it'd be met. I don't think I need to go through local law 1 because it sounds like you've all read it and you're very familiar with it. So I'll just end by saying that the interpretation that's being asked by the opposition group would result in an absurdity. And you cannot interpret the law or the resolution in a way which creates a legal absurdity. So, as you know, the Hyde Park Town Board is reviewing a petition challenging the second access road. The first access road is existing, that gets to continue under this local law. The absurdity, though, is that Hyde Park cannot rule on this petition until Clinton Planning Board completes its seeker review. That's the environmental review in New York State. It's what's called, there's involved agencies, and when Clinton is the lead agency, no one else can make a decision until Clinton Planning Board makes a ruling. We can't get back to Clinton Planning Board until you make your ruling, which means Hyde Park cannot rule on the petition until you make a ruling, until Clinton Planning Board makes a ruling. Should you rule any other way, it puts us sort of in a legal black hole that we don't know how to dig out of. It's a legal absurdity, and it would violate my client's due process rights. So in sum, your condition very explicitly referred to a defined term, the Hyde Park denials, as defined on page 2 of your findings, and the Hyde Park denials have now been reversed. There's nothing else to consider. Condition on its face has been met, and we ask that you allow us to proceed with the review before the Clinton Planning Board. I also want to note the Planning Board has requested an expedited review, so to the extent you're willing to accommodate that request, we would really appreciate a special meeting so we can move the Planning Board application forward. Thank you. Happy to answer any questions.
Yeah, any questions? Okay, thank you, Victoria.
Okay.
Hey, Warren.
Just give me one moment.
Yeah.
to Get my documents in order. My name is Warren Raplansky. I'm an attorney from with offices in the town of Rhinebeck, and I represent the neighboring property owners, Common Senses, Hudson Valley, and the town of Rhinebeck in various matters and lawsuits pending in Supreme Court with regard to this application. And I agree that was a fairly accurate analysis of where we are with this application at this time. The matter is before the ZBA pursuant to a resolution passed by the town of Clinton Planning Board on August 5th, 2025, to determine the limited issue as to whether the Hyde Park enactment of local law number 1 of 2025 and the related subordered stipulation constituted a final non-appealable decision, as that term was used by the ZBA in its June 4th decision. As this board is well aware, the Hyde Park zoning administrator determined that the proposed bridges and road access to the development from Hyde Park portion of the property was a use prohibited by the zoning code in the town of Hyde Park. And it's not a tiny piece of property, it's an 8.4 acre parcel, and the parcel in Clinton is 224 acres, I believe, if that's correct. The zoning administrator for the town of Hyde Park determined that as a result of that site plan and special permit approval could not be issued for the development because of the Hyde Park zoning code, which prohibits hotels and conference centers in the town's Greenbelt zoning district with the 8.4 acre lie. And also, the zoning administrator relied on well-accepted decisional law in the state of New York that access to a development project over property in one municipality or zoning district providing access to property in a second municipality or zoning district could not be legally permitted with a proposed use is prohibited in the first zoning district. I know that's pretty complicated. I'm sure your attorney can explain that to you at greater length, and I'm not going to cite the cases. There's a plethora of cases which support that. But the exact language used by the Zoning Board of Appeals, this board, in making your decision, and I'd just like to reiterate the entire language, if you bear with me. Our interpretation of the town code is that until legal access to the project site has been restored by the town of Hyde Park pursuant to either the Town of Hyde Park Zoning Board of Appeals reversing the Hyde Park denials, or the Town of Hyde Park zoning administrator rescinding the Hyde Park denials and thereby permitting access over the Hyde Park parcel, the amended application is not in compliance with section 250-24. That has not happened to date. And you stated, this is your language, we didn't create this language. We therefore reverse the letter of determination on this point and hold that the amended application fails to satisfy the road frontage requirements codified in section 250-24 because the Hyde Park denials prevent access to the project site. And here is the crux of your decision. We hold that until such time as the Hyde Park denials are reversed pursuant to a final non-appealable decision, the amended application is not in conformity with the town code and cannot proceed to the planning board for review. I would point out in what I've submitted to you, this decision is consistent with the requirements of section 250-97 of the Clinton zoning code, which requires the zoning administrator to review all applications for special permit approval to determine if the application is complete and is in compliance with all applicable provisions of the code, and to reject the application as incomplete and not complying if the application fails to meet those requirements. The rationale, and that's section 250-97, 2 and 3, the rationale for these requirements is clear in that logic as well as the law dictates that planning boards must ensure that all applications before it meet all of the requirements, standards, and criteria as required in the zoning code before initiating any review of the application. So if the application does not meet those requirements, it cannot move on to the planning board past the zoning administrator's determination. I'm sure you're aware, and I'm sure your attorney would advise you, that the ZBA, your ZBA is a board of limited jurisdiction and may only exercise authority properly delegated to it by the municipal code. The jurisdiction of the Clinton Zoning Board of Appeals in the instant case is strictly limited to consideration of the narrow issue presented by virtue of the referral from the planning board. It's also well settled law that the planning board can only decide the specific issue that was referred to it. And I've cited some other examples of the law which refer to that in my brief, which I've submitted to you. Just want to go over a brief history of the relevant facts because the history of this application is quite complicated. CECNY appealed the Hyde Park zoning administrator's decision to deny the application to the Hyde Park zoning board of appeals. That zoning board of appeals upheld the determination of the zoning administrator in a lengthy decision dated June 26, 2024, a copy of which I've annexed here too. That decision has not been reversed by a court. It was not appealed, it was not reversed by a court. On or about July 23rd, 2024, CECNY filed an Article 78 petition in the Supreme Court against the Clinton Zoning Board of Appeals and others in which it challenged the ZBA's determination, in that arguing that it was an incorrect determination, that the road frontage requirement was not met, and the decision should be reversed. I've attached a copy of that petition also to my submission without the exhibits. However, by notice of discontinuance, signed only by Ms. Victoria, co-counsel for petition, that action was discontinued. It never went to fruition. It was never decided by the court. On or about July 26, 2024, CECNY filed an additional verified petition and complaint against the town of Hyde Park and its CBA and zoning administrator and the town of Clinton, seeking a declaratory judgment and annulment of the Hyde Park zoning administrators and zoning board of appeals determination that the use of the Hyde Park property for access to the resort development on the Clinton property was illegal and should be declared null and void. I've attached a copy of that petition without the exhibits to my submission. Thereafter, Hyde Park Town Board enacted Local Law Number 1 of 2025, a copy of which I provided to you, and I'm sure you have. And the Hyde Park supervisor, during the course of the public hearing, acknowledged that the enactment of the local law was in response to the lawsuits filed by CECNY, and the passage of this local law was part of a deal brokered between the town and CECNY to avoid litigation costs in defending the lawsuit. That was the stated purpose of that local law. There was no stated public benefit. There was no rationale for passing that local law. It was only passed to settle a lawsuit, which the courts, I think, will find constituted illegal spot zoning or contract zoning. The parties to the lawsuit entered into a stipulation of settlement, which was so ordered by the court. I've attached a copy of that. However, after the enactment of Local Law Number 1, Common Sense's Hudson Valley, several residents of the towns of Clinton, Hyde Park, and Rhinebeck, and in addition, the town of Rhinebeck, filed a hybrid Article 78 declaratory judgment action in Supreme Court, Dutchess County, seeking an order and declaration from the court annulling and setting aside Local Law Number 1 of 2025. The petition, a copy of which I've also annexed, sets forth 13 causes of action, including illegal spot zoning, failure to comply with the procedural and substantive requirements of the State Environmental Quality Review Act and enacting the local law, violation of the seeker rules against segmentation, invalid exercise of the town's police powers, violation of the Hyde Park Comprehensive Plan, failure to make proper referral to the Dutchess County Department of Planning and Development, a violation of the New York State Rules of Uniformity, violation of the Greenway connections, and illegal contract zoning. That lawsuit was assigned to Judge Hayes and is still pending. It has not been decided. If that lawsuit is successful, and we firmly believe that there is a substantial likelihood that it will be successful, that local law passed by Hyde Park will be reversed, and the applicant will still not have any rights of access to its property in Clinton for this development. I have, the crux of the issue for you to decide is what constitutes a final non-appealable decision. And I've cited a number of authorities in my submission to you, indicating that when you interpret a zoning ordinance or a resolution, the reviewing courts apply ordinary meanings to the terms in question. When there is little or no ambiguity in the terms to be interpreted, or where the terms have a definite, precise meaning that cannot be reasonably misunderstood, the courts will apply plain and ordinary meaning to those words. A final non-appealable order is a final appealable order is one that determines a substantial right in such a manner that leaves no adequate relief except by appeal. Logic dictates that a final non-appealable order or decision is one which resolves all claims and issues in the case and is not subject to further review or appeal. If a decision may be further appealed or overturned by a reviewing court, it is patently obvious that the decision or order cannot be deemed to be a final unappealable decision or order until a determination is rendered, which conclusively determines the disputed questions. I've given you some authority, and I'm sure your attorney will advise you as to what guidance the courts have given in interpreting your own decisions and zoning ordinance, which I think are relevant to this case. The Court of Appeals, in a case cited at page 6 in my submission, have stated that in construing statutes, it is a well-established rule that resort must be had to the natural signification of the words employed, and if they have a definite meaning which involves no absurdity or contradiction, there can be little room for construction. The courts have no right to add or take away from that meaning. CEC's contention that local law number 1 and the so ordered stipulation of settlement entered into by the parties to that case constituted a final non-appealable decision has the legal, let me read that over, I'm sorry. CECY's contention that local law number 1 and the so ordered stipulation of settlement entered into by the parties in that case constituted a final non-appealable determination that CEC has the legal right to utilize the Hyde Park property for access to Clinton development violates every one of these rules of construction. In addition, the so ordered stipulation is of absolutely no consequence to what we're dealing with here, because so ordered stipulations are not binding on non-parties to the stipulation. It's only binding as a contract among the 3 parties that entered into that stipulation. I'm sure your attorney will advise you. The enactment of local law number 1 did not, as alleged by CECNY, constitute, as I indicated, a final non-appealable decision. And the reasons, there are 2 prime reasons for that. Local law, contrary to the conclusory and meritless arguments submitted by CECNY and their counsel, the enactment of local law number 1 does not constitute a final non-appealable decision permitting CECNY to utilize the property as legal access to its proposed Clinton development. There are at least 2 major avenues of appeal from that enactment of the local law, both of which have already been exercised by Common Sense's HV, the residents of the town of Hyde Park, Clinton, and Rhinebeck and the town of Rhinebeck. As stated herein, the enactment of local law has been challenged in a hybrid Article 78 declaratory judgment action. It's still pending before Judge Hayes, and the action challenges not only the enactment of local law, but the legality and propriety of the so ordered stipulation. If the petitioners are successful in that legal challenge, local law number 1 will be declared null and void, as will the so ordered stipulation relied upon by CECNY. The second reason is that although adopted in a patently illegal manner, as we have alleged in the petition, local law number 1 of 2025 itself, in relevant part, provides that any proposal to provide access to the development projects in adjoining municipalities which are prohibited under the Hyde Park zoning code must be evidenced by a notice of intent filed with the town and may be challenged by any residents of the town of Hyde Park in a petition filed with the town board on the grounds that the proposed development offends public morals, dangers or injures property, health, or safety of the residents of the town of Hyde Park. A notice of intent has in fact been filed by CECNY, but the neighbors have challenged that notice of intent and have filed a petition. The petition is still pending before the town of Hyde Park Town Board, and a hearing before the town board has been scheduled for October 20th, 25 on that petition. Until such time as the hearing on the petition is held by Hyde Park and a decision is made by the town of Hyde Park Town Board pursuant to the criteria set forth in local law number 1, there is no final non-appealable decision of the town of Hyde Park, permitting the 8.28 acre parcel to be used for access to the CECNY facility. I've attached copies of the 2 petitions that we filed with the town of Hyde Park. And finally, I'd like to address something that Ms. Victoria Polidoro mentioned in her original letter, that somehow Common Senses and their legal counsel have taken steps to delay the resolution of these issues by the planning board, the ZBA, and the courts. Nothing could be further from the truth. The Hyde Park declaratory judgment action was duly filed by the petitioners and on April 22nd, 2025. However, on April 28th, CEC NY's co-attorney, Mr. Stenger, who's here tonight, filed a motion in the Supreme Court seeking to disqualify my law firm from representing the parties in that action. By order dated July 7th, 2025, a copy of which is I also annexed here too, Judge Hayes denied that motion, finding that it was meritless. However, that motion delayed final resolution of the court case for over 7 months. That was the delay caused by the attorneys for CECNY. In addition, Mr. Stenger also filed an application with the Hyde Park Town Board seeking rejection of the petition that the property owners filed pursuant to local law number 1 on technical grounds. We had a hearing before the Hyde Park Town Board, and the Hyde Park Town Board also determined that request was meritless and denied it. However, that frivolous motion has held up the determination of the town of Hyde Park on the merits of the petition filed for local law number 1 for many, many months, and the matter is not even scheduled for a hearing as a result of that until October of 2020. There is not a single act on the part of my law firm or Common Senses Hudson Valley, the residents of Hyde Park, Clinton, or Rhinebeck, or the town of Rhinebeck, which in any way has delayed the final resolution of these issues. And we're offended by the notion that what we are doing is trying to delay this, when the only delay has been caused by the spurious and meritless motions that have been filed by CECNY and their attorneys. And we fully expect there'll be more of these motions filed in the Supreme Court. For all of the foregoing reasons, and for everything that we've annexed here too, we request that the Town of Clinton Zoning Board of Appeals issue a determination that to date there has been no final, non-appealable decision or order permitting the application process for this facility to move forward with the Town of Clinton Planning Board. It not only violates the specific provisions of your code to allow this to move forward, but it would constitute an enormous waste of time and resources for the planning board, for the citizens of this community, for your consultants to be involved in a process which has a very strong possibility of being overturned by the courts and by the Hyde Park Town Board itself. So I thank you for your consideration, and if you have any questions for me, I'm happy to answer them.
Thank you, Warren. Any questions? Nope, thank you.
And if you need any extra copies, we did make extra copies
We
for
have
you.
plenty.
Do you want a couple? Do you need? No, okay.
Digital works pretty well.
Yeah, I know, but it's a lot of copying.
They're posted, whoever wants them. So.
Thank you very much.
Is it really cold in here, or is it just me? It's very cold.
Yeah, if you want, you could turn it.
Usually the heat's hotter in these kind of hearings,
Yeah.
right? But it is a little cool.
Yeah.
So, hello, everybody. My name is Mike Oates. I'm the president and CEO of the Hudson Valley Economic Development Corporation. We've been in front of you
Sorry,
before.
you're echoing. Mike, what? Can you just push back the, yes.
Closer?
No, back.
No,
Farther.
back.
Oh, back.
Yeah.
No, you're back
Yeah.
farther is good.
I'm getting
Yeah.
confused. Come closer or farther away?
Farther away.
Okay.
It's echoing, I'm
Got
sorry.
it.
What's your name again? Sorry.
Sure. My name is Mike Oates. I'm the president and CEO of the Hudson Valley Economic Development Corporation. We've been in front of you before. We're strong supporters of this project. And I'm not a lawyer, but I'd like to try to keep this as simple as possible. I think Victoria did a great job in her summary. But as I look at it, it's this. It came in front of you. You reviewed this, you listened to comments, you looked at the application, and you rightfully said there's a portion of this that has to be decided in Hyde Park. Hyde Park then took it, they looked at it, they reviewed it, they made a determination and passed their law. To me, that seems to be pretty straightforward, that this project is ready to move forward through the approval process, and that it is not appealable at this point. So I just wanted to keep it simple. I want to thank you for your consideration. I think the town of Hyde Park also did strong and thorough consideration where they move forward with the passing of their law. So we're hoping that this can move forward. We believe it's going to be a strong project for not only the town of Clinton and Hyde Park, Dutchess County, the Hudson Valley as a region as a whole. So again, we're in strong support. We appreciate your consideration. Thank you.
Thank you.
Sure.
You state who you represent again, you're not anything to do with CCNY, right?
No, we're the Hudson Valley Economic Development Corporation. So we're a nonprofit organization trying to further and develop the economic vitality of the Hudson Valley region.
How much of an area do you cover, Hudson Valley, all it's
So
Albany,
we're
or-
9 counties, so Columbia, Greene, Sullivan, Ulster, Orange, Rockland, Westchester, Putnam, and Dutchess counties. Okay,
Thank you.
great, thank you.
Any further comments?
Hi, my name is Donna Burns, and I want to thank each and every one of you. When I came before you last year, I didn't really know much about land use and zoning, and I have learned a lot. And one of the things I've learned is I'm really grateful for each and every one of you for doing this work. It is not easy, and I know you're volunteers, and I know you give up time with your families and your personal time, and I'm extremely grateful that you do this work, because Clinton may be a small town, but you have to comply with the town law, and you have to comply with New York State law, and your service to protect the residents of the town and the future of this town really means a lot, so thank you very much. I only have a couple of points. I appreciate that you said this is a legal interpretation, and I agree with you. And I do think a lot of people have feelings about the project and whether it should go forward, it shouldn't go forward, but I recognize that that's not why we're here today. As a concerned resident and a member of Common Senses Hudson Valley, I completely agree with what Mr. Raplansky said, and the submission that the group made, and so I'm not going to repeat that here. You have it, just a lot of paper or a lot of bits. But it seems very apparent to me that there has been no decision on the road access yet, and let alone a non-appealable one. And but I do want to mention a couple of things. I am very personally disturbed at the conduct of this developer who has tried to pose this as a battle between them and the residents of this town, which is not how I view it, but it's clearly how they've been viewing it. CECNY and its attorneys have consistently sought to interfere with the ability of residents to come out and speak on this project in whatever context. They consistently argue that the residents don't have standing to come out and speak. They continue to raise all sorts of baseless arguments, just like Mr. Raplansky stated, this idea that there was somehow a conflict of interest. I heard this repeated to me. When a rumor gets spread into the community, it really gets legs, and so people started telling me this. I'm fortunate that the court has said that's not the case, but sometimes these things just get pushed out. Naming residents' names in filings, in the letter that Mr. Stenger filed on July 18th. Names of residents were put in the caption. There's no reason for that other than to intimidate people, because when people see their names on a legal pleading, they get very intimidated, and it serves to kind of chill what they say and whether they come out. Filing all sorts of motions, as Mr. Raplansky mentioned, and I can only guess that this is to cause the residents to expend money to fight these motions and cause them to get weary and tired and not come before you or any other board and exercise their right to express their legitimate concerns. False information in the media, stating things that are just not true. And this kind of legal bullying tactics doesn't belong in our good administration of government. So I really just wanted to make sure that you understand that. A lot of people have communicated that they couldn't be here tonight, because as you may know, we're on the cusp of Labor Day weekend. This is the last week before school starts. Anyone who has children or grandchildren, I have grandchildren who are starting. And so, you know, it's unfortunate, but that's just the way it is. And I think, you know, maybe some of the members of Common Sensus Hudson Valley knew about it, but because this meeting wasn't convened with a resolution here and then a following, I think it would be really, I urge you to consider that there are people who have opinions, but weren't able to be here, and I'm glad to hear that there were 30 letters or so forth, whatever they said, whether it's relevant or not. But it's an important issue to the community and also how you conduct your business. So thank you very much again for doing all this work, and that's all I have to say.
You're welcome, Donna. Thank you for sharing.
Well, you've heard my name often enough here in the last 30 minutes. I thought maybe you ought to hear me.
All right.
You know, I like what the chairman said. We have no lawyers on this board. That's great, because that means you got a lot more common sense than most of the people who do what I do for a living. And this question before you tonight. Oh, so sorry. What do I need to do? Kenneth M. Stenger, attorney at law. They all know who I am. They'll tell you I'm me. So the question before you tonight is, I understand, because I wasn't part of this process. I came in on the Hyde Park side of it. But as I understand this, at the end of your review, you took note of developments in the town of Hyde Park, and you had a purpose in mind. And you said, listen, until this access issue is restored or resolved, we don't want the planning board to continue to make this continue to go forward, because we got to have access to do it. And at that point, whether there was access or not was an open question. And that was your purpose. And I think after listening, if you'll notice, I don't have as many papers as any other lawyer in this building does. But in listening to Mr. Raplansky's argument, is it a non-appealable final decision? That's not the question here. Because the question is what happened served your purpose? You don't elevate the means. I mean, I've got this whole conversation about appeals, and you've heard enough of that for tonight. But I think the question is simply this. You had a purpose, and your purpose was get this issue resolved. If that access cannot be restored, we don't want the planning board to go forward. But you use the language. You say our interpretation of the town code is that until legal access to the project site has been restored by the town of Hyde Park, you can't go forward. That's your purpose. Now, you shouldn't be held to a standard where you have to list every means by which that can occur. It certainly makes sense. I think every lawyer in the world, what I know, had said, listen, we've got to have a final non-appealable decision. That's a good indicator that it's been restored or it's not been restored. But as you sat there in June, you could not have imagined what was going to happen 6 months later. And you have to think tonight, when you finish this up, what was your purpose in adopting that condition? Was it your purpose to say, well, we'd better see a decision that's final and non-appealable, or was it to make sure that the restoration of that access occurred in the town of Hyde Park on a basis which was final and non-appealable? And that brings us to what happened in the town of Hyde Park. I know that Mr. Raplansky enjoys enhancing my reputation for being able to bend the will of governments wherever I go. But it didn't happen that way. We had a litigation. Litigations cause conversations. The town took the position, the town leadership took the position that it did not want to shut down a project in Clinton because it required access through a piece of land in Hyde Park. And so they passed their law. And their law had that effect. And I don't want to spend a lot of time reading to you, but I just want to read a bit of that statute because it has that effect. It says, nothing in the town code, this is the law, nothing in the town code shall be construed to prevent access over any private road or driveway through the town of Hyde Park and to a property located outside of its municipal boundaries when that access is serving a use which is permitted by the adjacent municipality, and the town of Hyde Park Town Board has not adopted a resolution prohibiting or regulating the use of that access for the use permitted in the adjacent municipality, provided the property owner or authorized representative gives notice to the town's building inspector, so that the people in Hyde Park can have an opportunity to voice their opinion. But that language in that first paragraph, it restores access. And until that law is set aside, that access is restored. It can't be questioned that, now there is the statute goes on to set up an ability for the people of the town of Hyde Park to say, listen, we don't want that access to service that project. And we may have good reasons, we may have bad reasons, but we want to be heard, and they can be heard. But unless there is a vote from that town board at the end of that petition that says, oh yeah, okay, fine, this is all done, the access is closed off, it's still open. So as we speak today, it's open. If there's any question about that, is in the last part of section A, it says, any determination made or action taken by either an administrative board or an administrative officer prior to the adoption of the local law, and which does not comply with this section, shall be deemed null and void and without force or effect. Any such use which exists at the time of the adoption of this local law shall not be affected by it. So that statute, that language says, okay, that decision from which an appeal was expected to be taken by your board doesn't exist anymore. How do you have an appeal without a decision? You don't have an appeal without a decision, and there is no decision. The statute now in the town of Hyde Park says that access is open and unfettered. It's subject to the ability of the public to be heard. It's subject to the town board saying, okay, after we've heard the people, we may say, in this instance, you can't have that access anymore. In which case, you don't, in which case, we're all back to where we were at square one. But that hasn't happened. And the law is in place, and it is controlling, and it's not been set aside. And I know that my co-counsel has made that point better than I could here about 20 minutes earlier. But I do want to just make sure that we're clear on this. there was a stipulation, a settlement that followed the adoption of this statute. And the provisions in this are agreed to by the two town boards. You guys weren't a party to it, but by the two town boards. Paragraph 3 says, the access drive and the proposed modifications to it on the Hyde Park parcel are permitted to serve the conference center. Are permitted to serve the conference center. Paragraph 4 says, modifications to the access drive and the proposed highway emergency drive are permitted on the Hyde Park parcel pursuant to the provisions of Local Law 1 of 2025. So the statute that was passed then makes its way into a court order as the basis of of ending a lawsuit between CECNY, the town of Hyde Park, and the town of Clinton. And the language that people choose to put into the stipulation of settlement acknowledge that what you wanted, which was the right of access to be restored, has in fact occurred. And the only question is, does it have to occur only by a final non-appealable order? Or are there other means that effectively restore it? And it was your purpose, and you'll make the decision, because this is very interesting. You get to review your own decision. You'll make a decision whether your purpose was to limit the ability to restore that access to a certain form, or whether your purpose was to say, we don't want the planning board to go forward until the issue of access is resolved and restored. Because if your purpose was the second one, it shouldn't matter what form the relief occurs in, right? It shouldn't matter if it's A, B, or C, so long as it results in a restoration. And I think when you sit here and spend 20 minutes explaining how the law says that, well, this is what a final decision is, and here's what it means when it's a final decision, and here's what it means when it's a final decision. That's what lawyers do. We put the cart before the horse all the time. And we shouldn't, because it's real simple. What was your purpose? Was this purpose served? I'll tell you one person who surprised me, but acknowledges that the purpose was served. I just got a letter from Kathleen Moss. She's a CEO in the town of Hyde Park. And I sent it over. I didn't, forgive me, I fought the temptation of not giving you a 30-page letter this afternoon. I sent a little letter over and said, here are 3 exhibits. I don't know if you received all the exhibits or not. If you did not, I will give you a copy of Ms. Moss's letter that should go into the record. But what happens here is, first of all, let's go through some history. All of this controversy about this lack of access starts with Ms. Moss. She's a CEO in the town of Hyde Park. Well before I got involved in this, she gave an opinion that access for the project in the town of Clinton could not be had through the 8-acre parcel that was owned by CECNY in Hyde Park. That's where this all starts. And there was an appeal taken from her decision that went to the ZBA. The ZBA supported her. That's when you've come in and say, wait a minute, until the issue is resolved, because we got to have access, let's stop right here in the planning board till we have that done. Now, since that date, the law in Hyde Park changed. Hyde Park town government said, look, we're not going to have appointed bodies or appointed officials have the ability to shut down projects in other towns. If anyone's going to do it, it's going to be us. There's going to be a presumption here on out that any project in another town that has access through our town gets to use that access unless we decide otherwise. That's what the new law says. And one of the things that we had to get done was within that parcel of land, there are 2 roadways. There's one that's a historic one that's been used, and there's a new one that's going to go in there because DOT wants it in there for emergency ingress and access. And there's going to be a bridge involved with the emergency ingress and egress. And because there's a bridge involved in it, we have to get site plan approval. In order to get site plan approval, we got to go back to the planning board, which means we have to go back through Kathleen Moss's office. So, I'm a little concerned. Okay, she was a named defendant, what's going to happen now? Are we gonna go through this again? I know Tad professionally in other settings, but certainly I'm not going to pick up the phone and talk to her. I can't, I shouldn't. So I send the letter in, and I hope that this is gonna all be okay, that she is going to accept what the new law says, and she's gonna accept the fact that we have access, and she's gonna let us go forward with the site plan approval that we need for the bridge for the emergency access. And I have her letter today. I got a letter actually yesterday, before I got any of these letters from Mr. Raplansky or his clients. I got the letter from Kathleen Moss, and it says, yeah, go ahead. You've got your site plan appearance before the planning board. I'm signing off on it. It says that, I'm not going to read it to you, but I'll give it to you to read. You have it, right? Oh, you don't? Okay, I'll give it to you right now. Well, let me just, if you won't mind, I'll just read it, because it'll be new to everybody. Dear Mr. Stenger, I have received a copy of the stipulation of settlement and your request for confirmation of paragraph 5 in the settlement, that the parties agree that the following are the only approvals from the town of Hyde Park which are currently known as required for the access drive and the proposed emergency drive to allow access across the Hyde Park parcel to and from the Clinton parcel, which is subject to the approval of the town of Clinton and may be used as a conference center. And then she identifies we have to get a floodplain development permit, a stormwater pollution prevention plan review, and a site plan approval for the proposed bridge and the proposed driveways. If her position remained that we did not have access, she wouldn't say we need any of these permits, because if we didn't have access, we wouldn't need them. She goes on to say, I have reviewed these documents and with the advice of the attorney to the town, note the following, and based on the description in the stipulation of settlement, so ordered by the court, it is understood that there are no other development features or structures proposed within the access parcel in the town of Hyde Park. The new access and bridge are to be used only for emergency purposes and not general service or supply vehicles. The proposed driveway connecting the new bridge to the extent of the NYS DOT jurisdiction will also be addressed under site plan review for emergency access standards and safety considerations, and aspects of the floodplain development permit and any stormwater pollution prevention plan facilities associated with the new bridge and emergency access will be shown on the site plan. Development within the stream corridor will require variances subject to section 108-4.3G2. The last thing she said to me is, current development plans do not accompany the stipulation of settlement nor your request. Any additional improvements to the site beyond access, bridge, and changes associated with the stormwater and floodplain development measures will be subject to the code of the town of Hyde Park. I appreciate your patience in allowing me to read this letter. When I got it, I was relieved, because it meant that we were able to go forward with what we have to do in Hyde Park to put the bridge in so that we can go forward with our access. It meant that she recognized the fact that we now have access. It exists. It's been restored. Your purpose has been served, as witnessed by Kathleen Moss's letter. It didn't really strike me how important this letter was until I got bombarded this afternoon with letters. Some of which I read here, some of which I read in my office. And, the point is that, I guess the point is simply, has the adoption of local law number 1 in Hyde Park restored access? If it has your purpose been served? I think that's the question, not the means by which your purpose has been served. And to me, when I read this letter again, after I read the massive letters I received today, I was saying, this is great. This is my best evidence to you, to show to you that somebody who in good faith disagreed, in good faith said, nope, that shouldn't be available, has acknowledged the effect of local law number 1 and is now saying it is available. Because if it wasn't available, why would we have to make these applications to put in that bridge? All you'd have to do is write a 2-paragraph letter. You don't have access. Shouldn't do that. So I think that's my point. I appreciate you giving me a shot at trying not to sound like a lawyer. I know I didn't do it completely, but
I just want to add that the Hyde Park review cannot go very far until this application goes back to the Clinton Planning Board for completion of an environmental review. So even though Hyde Park is now allowing this application to proceed, this board has to confirm that the condition has been met to release everyone back to their boards.
I just want to, I appreciated the colloquial language, but at several points you used the phrase, we wanted to see access restored, or that our purpose was to see access restored. And obviously, that's not the case. We take no position on whether the pros or cons of access being restored and our language was until access is restored.
I apologize.
Yeah,
I was not trying to give the impression that in saying you wanted it restored, that somehow you
Right, I
favored
just
it
wanted to-
being restored. Let me be now I'll be lawyerly.
Yeah,
That's what happens
I just
when you're
wanted
not
to
lawyerly.
make that clear. And then,
Here's the-
Ms. Moss had the luxury of not having had someone saddle her with the language of a final, non-appealable decision. So she had a simpler job than we have here,
I just want to make that
unfortunately
clear.
for us.
I was not trying to insinuate
No,
that you had
I
made a
just wanted the
decision,
record.
but you favored or didn't. I just was trying to make it clear that what you were looking for, your purpose, was to see whether or not that access would be restored. And if that was your purpose, and if you find it has now been served, then your interpretation ought to be to let this project go forward.
Thank you.
Thank you, sorry.
Do you want to give me that copy or get emailed
Oh,
with
sure.
it or whatever? Thank you.
Thank you.
Excuse me, let me talk. Sorry, I just wanted to respond to that outrageous presentation. This letter, I don't know what the genesis was, but I'm sure some pressure was put on Ms. Moss to produce this letter by Mr. Stenger and probably the town board. However, when you read the letter, it's clear that Ms. Moss has not reversed her original determination. All she said was, in light of the local law, this is, I'll abide by, what I'm directed to do by the town board, and this is what you need to do. She did not reverse her decision that under decisional law in the state of New York and under the statute in Hyde Park, this access could not be permitted through the town of Hyde Park. She did not say that the zoning law now, which has not been changed, because the local law, if you read it, did not amend the zoning law. It amended the code. I don't know why they didn't amend the zoning code, but the zoning code is still in existence. I mean, it's unbelievable. But this is hearsay, and it means absolutely nothing. Ms. Moss has not reversed her original determination, and her determination was upheld in a very lengthy decision by the Zoning Board of Appeals. That has not been reversed. The stipulation that was entered into by the parties cannot reverse a decision of the Zoning Board of Appeals or the zoning administrator. And we've argued that in our case pending in Supreme Court. What has to happen is the matter has to go through the Supreme Court and a determination has to be made. I understand the applicant is in a difficult position, but the applicant should have investigated all of this before they purchased the property and made application. Most sensible developers make their purchase of property for which they are intending to develop it conditioned on approvals by the town. That didn't happen. Six Senses spent $14 million buying a piece of property that didn't have legal access. That should have been a big red flag to them before they started this. And now they are bullying the towns, both towns, into ignoring the law and basically permitting them to proceed with what's not permitted either in your law or the town of Hyde Park law. Mr. Stenger makes a great point of quoting from the local law number 1, but he doesn't read the whole section of the local law number 1. The section, let me just read this. Any determination made or action taken either by administrative board or administrative officer prior to the adoption of this local law which does not comply with this section shall be deemed null and void and without force and effect. It's been argued in the Supreme Court case that a town board does not have the power to reverse a determination by its own zoning board of appeals. So that stipulation and that local law is of no consequence because it's illegal. And it goes on to state that any resident of the town of Hyde Park or a majority of the town may petition the town board to entertain a resolution prohibiting the use of the driveway or private road located or proposed to be located on lots in the town of Hyde Park as access to a lot located in a different municipality, which lot is adjacent to or part of the lot on which the private road or driveway is located or proposed to be located. On the grounds that the use occurring or proposed to occur on the site offends the public morals or endangers or injures the property, health, or safety of the residents of the town of Hyde Park. The petition shall be filed with the town clerk within 30 calendar days of notice to the adjoining property owners, and a hearing shall be held. This is the local law. You can't read a portion of the local law without reading the entirety of the local law. And the entirety of the local law says the decision that we've made, which we think is patently illegal, is subject to a petition filed by members of the public. And that petition has been filed, and until that petition is determined by the Board of Appeals, this local law is of no consequence to the issue of the legality of the access. And it's just outrageous that they would read Ms. Moss's letter and see whether she has, in fact, reversed her original determination that the access is illegal. All she's saying in here is, in light of this, this is what you need to do. And I'm sure that this was prompted by CECNY, Mr. Stenger, and other interested parties in this development.
But are you suggesting that she violated Hyde Park Town law in allowing them to proceed to the planning board?
No, I'm not saying that. I mean, her original decision has not been reversed. She has not reversed her original decision, which is that the decisional law and the Hyde Park Code do not permit this access. All she's saying that in light of this stipulation, this is what you have to do. She's probably bound as an officer of Hyde Park to follow the stipulation as illegal as it is until it's overturned by a court. And it would be interesting to have, instead of Mr. Stenger bringing this in, and providing his interpretation, have Mr. Moss testify as to what the genesis was of this letter. But I don't think you can rely on this letter for the presumption that she has changed her opinion. That is not what's in here. She's saying that in light of the law, this is what you have to do. She's an employee of the town. She has to follow what she's directed to do. I understand the seeker issue, but you cannot move forward with an environmental review of a project which is not properly before the planning board. And until this issue is resolved, your own code does not permit the action to move forward with the planning board. Seeker does not trump the town of Clinton code or the requirements of the law. Until such time as this issue is decided, you can't move forward with a seeker review of this project either. I'm sorry. That's what the law says. And I think the board, of course, you'll make your own decision. I think you would be well served by allowing this to play out before the Town of Hyde Park Board and the courts before moving this project along. Thank you.
Thank you. Come forward.
Hi, everybody. Thank you so much for being here. I don't envy any one of you in this situation. And I know that you volunteer your time. Do I need to get?
Yeah,
You're good.
sorry, I know you, but you have to.
I'm sorry.
You're actually better staying farther away because it
Okay.
seems to not get as
Yeah.
much static and
Okay.
feedback.
The echo.
Okay, hi.
Name.
I'm Wendy Maitland, and I am a resident and business owner in the town of Rhinebeck. I was born and raised in the area, actually in Statsburg, where we had a Statsburg address and a P.O. box in Hyde Park, and went to Rhinebeck School. So I'm familiar with being on the edge of a town and having things be confusing. But I've been following this closely, and I don't think I've been before any of you before, but always full disclosure, I was the broker who represented the seller in the transaction that CCNY purchased the property through. And so I've been following it closely because I've gotten to know their usage throughout the planning process. It took, almost a year for them to close. And I also had the benefit of seeing who else was interested in purchasing this property over the course of almost 3 years. And the other people, without exception, except for one who was an end user who didn't end up being interested, out of dozens who saw it, were developers, were mass home developers, and looking to squeeze every inch out of their residential portion of the zoning, which would mean, dozens and dozens of homes that are kind of as of right, whether or not there would be issues. So I'm really supportive of this project, not only because it is not that, which would be heavier usage, but also because I've gotten to know the ethos of the brand, and that, in my estimation, is very much authentic. I met one of the very first people who built Six Senses, Neil Jacobs, and it's for real. There are environmental concerns and there are health and wellness objectives, and I know this is not what it's about, so let me get down to this issue. One thing that I think is important is that I was at that Hyde Park Town Board meeting where the town attorney talked about the decision to enter into this agreement and to start implement local law 1. And the reason is being called spot zoning, but I didn't interpret it as that at all when I was there, because the lawyer for the town said that a major reason was that they were doing all kinds of projects and have all kinds of boundaries themselves in Hyde Park, and Hyde Park does not want to be subject to the reverse situation where only the access would be in Clinton or in another neighboring town, and that could prevent the entire project from going forward. So that was a big part of their rationale. I don't think that they're going to reverse on that so quickly. It also sounds like the stipulation language is very, very clear and would also be complicated to reverse, given that it contains the very phrase that you're trying to determine whether or not it rules here, right? Another thing, sorry, I wrote a note that I wanted to say. Oh, and so the right to appeal, I was very attentive to the fact that there's a reason that has to be given. I'm sorry about this. I feel like this microphone has a life of its own. I'm trying not to hurt anybody's ears.
Oh, yeah.
Oh, my goodness. Thank you. Sorry, I just took a note. So there's a phrase that if this isn't exact, it's very close, that Hyde Park citizens can petition against a project in this situation if it offends morals or endangers the safety of people. I would find it really, I would be hard pressed to see how what is being done would offend morals or endanger people's safety. I think that this group, CECNY, has gone as far as anybody can to observe the laws and the rules and to proceed properly with the process. And so obviously I support this as a resident in the community, as a lifelong resident who cares about the character and history and environment, and wellness, which my parents also happened to have a wellness retreat in Statsburg when I was growing up. So I'm thrilled to see something like this potentially coming to the area, because I think it's beneficial. I think it's economically beneficial, and also I think it's very good for property values to have something like this rather than a fly-by-night home developer slapping up houses, for example. Lastly, I know that it's been stated several times that the town of Rhinebeck has joined in the opposition group's lawsuit. Being a resident of Rhinebeck and a business owner, I did attend the last moment called meeting of the town board before they took action on this. And a couple of things really struck me as not correct or right. There was no video taken, and there was not only no allowance in an implicit way for town citizens to stand up and ask questions or understand anything about this lawsuit or why it was happening or what was the rush about this. There was literally a statement by the town supervisor that there would be no public comment. And I found that very, very upsetting, and along with a couple hundred other people in Rhinebeck got behind a petition against it, and they haven't responded to that yet. So when you hear the town of Rhinebeck is also joining in on this, it's the town board that made the decision with zero input prior to the decision being finalized from Rhinebeck citizens. So that's kind of a disturbing part of all of this legal stuff for me. And I guess that's it. I hope that you'll seriously consider your big responsibility here as a board of non-lawyers in the context that you need to, and come to the right decision. And again, I'm really very grateful for your work, because I know it's not easy. I've been on a lot of thankless boards making tough decisions. So I wish you the best of luck, and if you have any questions, I'd be happy to answer them.
Thank you.
I did have a question, if you don't mind.
Yes.
Just to make sure I understood you correctly, in Hyde Park's adoption of Local Law 1, it wasn't solely for this particular instance. Did I understand you correctly, that there are other projects?
Yes, and I think if you pulled the records from that meeting, you would hear, and I don't have an exact quote, because, you know, I'm not getting paid to be here either, but I was there, and the lawyer for the town, in explaining the decision, specifically said that a large reason for that was that as a town, they wouldn't want to be on the other end of the situation that the town of Clinton was currently in at that moment.
Okay, well, thank you.
And I can try to find it, and I'll send it along to Arlene if I find it. Thank you very much.
Any other comments? Tommy?
Are those cookies?
Those are, would you like one?
I'm Tom Trout, I'm from Rhinebeck, and I served as town supervisor at Rhinebeck from 2008 to 2004. T-R-A-U-D-T. Trout. Sounds like the fish, but not spelled the same. So I was supervisor at Rhinebeck 2008 to 2014, and in that time, in 2010, we adopted a comprehensive plan, together with the zoning and freshwater wetlands law. So I can appreciate what you're sitting through. You're not going to make everybody happy, and it's difficult, I understand. I don't want to talk about legal stuff. I just kind of want to get to appealing to the community of Clinton to listen to the developers of CECNY and the Sixth Senses project. And despite all the legal hostilities you may feel through all of this, there is a concern for a community with the project to embrace the values of what you have here. Your comprehensive plan and zoning law seeks to protect the scenic, historic, and environmental cultural values of your community. I should probably talk slower, right? I have that problem. The most difficult and valuable part of public service is the protection of our values and how we can guarantee it. I believe Sixth Senses project supports the Clinton community and the Hudson Valley community together. All the concepts of the community preservation exist in their project without demand. Sixth Senses project seeks to embrace all community values. In fact, they want to embrace all these values of the community of Clinton and the Hudson Valley. Preservation of scenery, including open space, natural resources, natural wetlands, the woodlands, the preservation of historic buildings, and the peacefulness and surrounding the environment. They embrace these benefits of Clinton and the Hudson Valley at large. Sometimes the resources of larger developers marry with communities' needs and visions for their future. Because they have the resources, they embrace these details to keep the scenery, the scenic values of Clinton. They don't look to develop skyscrapers or large parts of the property. Of the 240 acres, I understand only 3 acres are going to be developed. And call it what you may be, it's not a conference center, a resort, so on. This is a spa that needs to have peace and scenery, and you guys are laughing at me, and also the, what do you call it, sorry, the ideals of what we enjoy here. So I'm appealing to all of you and the community to listen to CECNY as they move forward and to not take the hostilities at heart. Just let them explain what they have, and I'm sure you will see that your values are together with theirs. Okay, thank you very much. I'll give you my letter.
Thank you.
Any other comments from the public?
Okay. Testing. Okay. I'll try to keep my phone away.
Yes.
Start with the name, please.
Yes. Hello. My name's Kate Kester. That's with a K.
How do you spell the last name?
Kester. So, hi. I'm a Rhinecliff resident, and I'd like to state my support for Sixth Senses project and ask that the ZBA move forward with the application. As an artist and designer in the local area, I work with many other artists, galleries, nonprofits. The arts are hard and rents are high, and I really appreciate the commitment of Sixth Senses to providing opportunities for artists. And personally, I can attest to the many artists I've talked to, and they're excited to get these collaborations going, and for artisans and wellness leaders. So that's something I really appreciate, keeping it positive. And I just did want to note that something I don't appreciate is the overuse of the word bullying. Just keeping in mind mental health and real real bullying is a real problem in this country. So I just wanted to note that. But yes, as an artist and a small business owner, I'm very much in support, and I would like you to move ahead with the application. Thank you.
Thank you.
I think certainly the residents of the town of Clinton know that the town will soon be embarking on a new comprehensive plan. There's been a lot of talk about the comprehensive plan and our sense of the rural character of the town. And I'm really looking forward to finding out exactly what people mean by that, because I think we have a lot of different opinions about what is meant by rural character. The town is also looking very carefully at its town law regarding, yes, we have to call this a conference center. No, I never wanted to do that, but it is in fact, does in fact meet the definition of a conference center under a town code. So I think, you know, the town has learned a lot from this process that we need to think very hard about exactly, and there will not be agreement among everyone on exactly what rural character means, and hopefully we'll find a way to balance that. So, but again, we at no point either in our June 2024 decision or tonight do we get to take that into account, right? Our job here is very narrow and very specific in interpreting the existing town law, not what we might hope town law becomes. So that's just my personal opinion.
Any further comment from the public at this time? All right, that's nice. Do we?
I make a motion that we close the public. I make a motion that we close the public hearing. Oh, sorry.
Do you want, it's up to you guys, but do you want to allow time for written submissions? You don't have to have a couple days. If you don't have to.
Yeah, we've got plenty to work on.
40 or so.
So no submission anymore? Nothing? Even,
We have a lot to contemplate, but I would like to make a motion to close the public hearing.
Do we have a second? All in favor?
Aye.
So moved.
We have enormous piles of documents to go through, and we do look at them all. Whether you're talking about just the rural character of the town or the legal details here. We have received a memo from the town attorney regarding this issue, and at this point, I'd like to make a motion to enter into executive session for the purposes of discussing both the confidential attorney-client work product produced by the town attorney and the pending litigation involving the CECNY
We have a second.
application.
Yeah. Second, all in favor? Okay.
So we're going to disappear downstairs. I can't promise you that there will be much to say at the end. Again, we hope to move forward with this as expeditiously as we can, but we have a lot to do. No, we obviously do not anticipate a decision tonight. There's a whole lot of legal stuff that's going to get digested and settled.
So if you're thinking we're going to come back to make a decision, you can go home.
You can go
That's not going to
home.
happen
We're going to be
tonight.
here a while, but, and if you want to stay around,
Yeah, you're, of course,
you're
welcome.
you're
to.
welcome.
we're still gonna be live though, I mean,
Yeah. Well, if people are still here, we should go downstairs. Yes.
you want to drink some water before you guys choke?
Yes,
There
Yeah, text me if you guys get out. You can join us. Take care. Bye, bye. All right, shoot me a text if anything, yeah.
While she was lollygagging with Scotland.
Yeah, she said we could text her, we probably won't get her back.
Oh, yeah, let's do that. Let's.
Everybody shoot, we'll all text her.
Let's catch us in the right mood.
Okay, well, always nice to see you. Enjoy your holiday weekend. You guys are you working tomorrow? Yes. Okay, all right. All right, folks, take care, see you at the next one.
Don't feel that bad. Don't carry that out the top for you.
Actually came in handy.
Well, it did because he quotes, I've never read the resolution, but when I'm reading it, I'm going, wow, the first sentence says, here's what we want to see. Don't do anything until it's access to these streets. That's the purpose. I think you're in good shape there. They slept through you. They liked you. They thought that was fun.
We didn't respond to others in this. I haven't read through
No,
it.
there's nothing in it. It's just everything he said. I mean, the bottom
Did you
line
just read, is this what he read into the record?
it seemed to me that that's what he was doing.
Okay.
But the point of his argument is it's gotta be a final unappealable decision, final unappealable decision. I mean, is that the point? Or is the point it's gotta be restored? Which one is it? Tell me, you make your decision. You make your decision that it's final. If it's important you have that problem, the issue is it restored or not? Then it's fine. The issue is how it was restored, and then it's not done. What were you looking for? How it was going to be done, or was it done or not?
So, Catherine. Yes, ma'am. First time I haven't seen you with the needles.
Yes, because I'm ordering my groceries.
Okay.
It's like, oh, you're gonna go on executive tour? Great, I don't have to pay much attention.
Okay, very pragmatic.
Yeah, yeah, no, that, I couldn't possibly sit through these meetings without something for my hands to do. I'd either be throwing things or sleeping.
You're not even fast.
I know.
I'm going to sneak you something else.
Yeah. No, you just find my office out.
Oh, that was so fun with the village official.
What's going on? The fee stuff?
Good. No, yeah, we're filing against them on the fee.
Mm-hmm.
We've been,
I heard the project's for sale.
no, the project is not for sale.
There's a big for sale sign on it.
No, that's my office building. That's the one when we retire soon.
Oh, your office building's for sale?
Yeah, my office building's for sale, looks like I'm gonna buy
Your
it.
partners aren't gonna buy you out?
No, I'm not.
Oh, your law partners.
No, I know. No, I only have 25% of business. The guy had a partner in pretty poor health shape, so he wants to sell it. So it's a sign up front.
Makes me look like a frozen child.
Yeah, no.
Not a good one.
No.
Oh, is that what Hans called me to tell me yesterday there was a for sale sign? Maybe he was talking about your office.
There's no for sale sign on the
Okay.
project.
He was like, oh, your best friend's property is for sale. My best friend? You
That
know,
must be me.
he's you, I guess. And then Jackson Crossing, because that project gave you such a headache.
Yeah, she was such a dummy.
Who?
The mayor.
Oh. Fishka.
Yeah. Yeah. When I got involved, when I got involved, I'm like,
Better than Richie. You know what Richie did to me?
no.
Took me into a room once. I was like, I sign your checks, and I'm not gonna sign the checks if you don't tell the
No, we,
Her boyfriend, her former boyfriend, is not much help.
no, we won't miss the, we won't miss ZBA, we leave this Saturday after.
You want to call? The next one? I thought I was going to, hold on a second. She took the meat and potatoes and gave it to John first.
Good time.
What do you think of John?
I think he's a good lawyer, but I don't think he,
Did you get the signs?
I think he's a good lawyer, a smart lawyer, he's somebody on the team.
I didn't see
Not on my team.
Right,
I wouldn't want
Well,
to.
they weren't for them to put up here, we took them all home, everybody took some home to put up at home. Well, no, they're in the back of my house.
I didn't see it.
Oh, well, it's got to it yet.
Public
They're still in the back, mine are still in the back of my car.
I mean, you make good arguments in a way that are not
I
slanted.
think we're that.
They're there, you just gotta, it's not like you gotta listen to you, they're there, they're there,
Didn't-
digest. They're nice, pleasant way about you,
To South Carolina?
that invites the listener to
I don't,
listen.
I don't know how, what is. That's good to hear.
No, it's
Probably not here to hear.
That's good for everybody, everybody not
Here more
understanding,
than
everybody in the room is asleep.
He's not voicing about there.
Yes.
Fitness, yeah.
Yes.
But I think she likes it down there, so,
No, I think you enjoy it.
yeah.
Always the case.
I know that's why you want to go there. You can show them the difference.
What do you think? Grandbaby?
No, no, I should think about it. So for Christmas.
No, I have mine was on too. I mean,
Can't
I
really tell.
used to get really wound up.
That's bad.
My argument, I try to express
Yeah,
something
that's
that
very.
Pops of color in it.
the way they might understand. Often these don't.
Oh, did you find your plate? I put it on.
Yes, thank
I
you.
have to do it.
We were at the fair and Ron's sister was house sitting, so we came back like late Sunday night and there's a plate and the
I haven't
the
done.
Tupperware.
I haven't done an
I put the
appellate.
name.
Who wrote that note on there?
Well, it's
Oh, it's Arlene. Wait a minute.
It's like, where is it gonna be, like, it's not gonna break, you know, like, you know how sometimes the dog will jump on anything.
No, it's
Oh,
not.
it's right in the
It's been
shape.
sitting on top of the cabinet.
I will because
It's proposing his.
I was
I remember one day I was like, but I had to,
I
for some reason, I'm like, no, I can't stop that all the time. And then I totally forgot.
So I've been helping.
Oh, shit, I'm going there.
I appreciate that.
Going crazy.
Oh, yes. Oh, my God, they're awesome.
Thank you.
But, I mean, one was, well, I need like a plan.
Well, you know what, Mary Kate, there's some things I do these. I know we're doing these. Yeah, that's, I think this was good. And if I was, if Mike sees it, I don't see, when you were talking, 2 or 3 of these guys were looking at you smiling, and I was trying to figure out if that was a ordinary routine. And, here, they all fell asleep, I knew it wasn't their ordinary routine. I was watching one guy, and he was like,
Okay, we on? All right, do we need a motion to end the executive session?
Yes, to get back.
Okay, I'd like to make a motion to adjourn our executive session. We have a second? Okay, all in favor?
Aye.
So moved. Charlie, I'll kind of turn this back over to you to spearhead this
Yes.
discussion.
At this point, there is an enormous amount for us to consider. Specifically, just, we have to spell out exactly what we meant by the language in the resolution adopted June 4th, 2024. I'm not personally prepared to enunciate that. I'd like to spend time going through all the documents and hear, have chance to hear what the rest of the board thinks. And I think, I am sensitive to wanting to move this forward. I don't think we technically have, 62 days. We don't intend to, we in fact, it turns out that a number of the members can't be here on the normal day next month, and so we'd like to move up the meeting to the 18th, 4 weeks from today.
Wait, 18 what?
Oh, well, we gotta make sure she's here.
You gotta check.
Are you
with
around?
me. I don't know. What is this?
It's a Thursday.
September 18th.
September 18th. Oh, okay, so instead of 25th, you wanna do it on the 18th?
Yeah, move it up a week.
It's a week earlier.
Let me check the calendar to make sure that we have a room.
Nobody's gonna come.
No, a meeting room, I mean,
We know what you mean. While she's looking that up, Charlie, really appreciate you putting together, the summary and leading the discussion. We know that it's a lot, and it was very helpful to be so clear and succinct with what you put together to start us off focused on the right things. So certainly appreciate that.
All right,
Thank
we're
you.
good, we're good.
We're good?
We're good,
Okay, so the meeting will be September 18th, 6:30?
sure.
Okay, same time, 6:30 PM.
Okay, and that's all the comments I had.
Okay?
Will
Any-
that be the only thing on the agenda then?
No, I have for variance, that's gonna be going for next week, so there's gonna be there's gonna be 3 items on the agenda.
Okay.
Is that fine?
Three plus this one?
No,
So
2
three-
plus
okay.
this. So you think you're gonna be here until midnight?
Bring twice as many cookies.
Simple.
Okay.
You said you would not be here the 18th, right,
But-
John?
And
Who's gonna actually be here?
I'm not gonna,
These will be here all month.
The rest of us will be
And
here.
the rest of you are okay. We don't know about Frank, right?
Right.
You'll follow up with Frank?
We have a forum even without Frank.
Mhm.
Yeah.
Yep. Yep, well, 5. We need 4. As
So,
many as possible is ideal.
Public comments are no longer accepted?
Correct.
Public hearing is
Just-
closed.
So it shouldn't be, it'll just be whatever time is needed for our discussion, but we won't have, hours of
Yeah.
public comment.
Right. Yeah, we need to,
Wants me to answer, I can go down there, if you go and talk about anything, just throwing it out there if you want.
what's that?
If you want me to sit down there, do you have any questions or anything on this? I know we.
Oh, well, yeah, please, please.
There we go.
Microphone is all yours.
Yeah, I learned my lesson watching
Yeah.
Shane Egan, town attorney.
Is it fair for us to ask you your opinion of the meaning of the term final and not appealable? Or would you like to wait and,
I think the board, what you guys have to think about here is what was intended. I mean, the language is final and non-appealable. That's in your decision. It's not non-challengeable. Those are 2 distinct things. And there is, what we had at the time, what you guys had in front of you at the time on June 4th, 2024, were 2 Town of Hyde Park zoning administrator determinations which said they didn't have access. Those very specific things, those very specific rulings, and then the subsequent determination by the ZBA have now been reversed. And then there was a stipulation of settlement that was served with notice of entry on the parties to that proceeding. and 30 days after which, pursuant to the New York CPLR, civil practice law and rules, that becomes a non-appealable decision. So that's one way to look at it, and then the other way is non-challengeable. I don't know if the board meant it in the broad sense. So there's two ways to look at it here.
So is there any room for an appeal at this point versus a challenge?
From those very specific
Yes.
Hyde Park, those ZA rulings, and I would say no, there's no room for an appeal of those. There's room for a challenge, and in fact, there is one pending right now that's been brought by Mr. Raplansky and Common Senses HV and the town of Rhinebeck.
And strictly speaking, the local law 1 of 2025 in Hyde Park didn't sort of technically reverse, it nullified those two decisions. I mean, Mr. Raplansky made the argument that town boards can't overturn ZBA decisions. They didn't really overturn, they just nullified a decision. Is that a distinction that matters?
That's something I would like to research, to be honest with you, Charlie. But, you know, I guess I'll reserve judgment on that.
I mean,
before
I can give you an example of the town of Clinton Town Board overturning a decision of ours on Cornerstone.
That's true.
Depending on how you want to think about that.
Very similar, yeah.
Yeah, you know, they passed a law that rendered our decision null and void, that they couldn't expand a non-conforming, a non-conforming use, and.
I think that's a distinction versus overturning. They didn't come and say, we're overturning it.
Yeah, they're not overturning it.
The law was changed so that it no longer needed.
And so, to me, that is equivalent to reversing the decision. It just doesn't use I don't think Hyde Park, that null and void, not reversed. So the Hyde Park local law doesn't use the word reversed, I don't think. I just wanted to.
It's likely a distinction without a difference, I think,
Yeah, okay,
practically
good,
speaking.
Good.
It nullifies, which means without effect, and it's specific.
Yeah.
But again, that's what we can research. But the question, I think, for the board is, again, non-challengeable versus non-appealable.
Yeah.
And that's your decision to make, not mine, obviously. But what was the legal sense of non-appealable?
Yeah.
In that narrow sense, on those two very specific determinations of the town of Hyde Park, there has been some conclusion to that.
I guess I am
non-appealable, in my
prepared
opinion.
to say that my personal feeling is that if we had meant to say that the town planning board could not proceed until all possible challenges to access had been met, we would have said that. That's my personal feeling. And so I think that's a decision for all of us to make.
Shane, is there a time limitation on challenges, for example, in Hyde Park?
I think conceivably there could be they could go on. I mean, it depends on the specific type of challenge. I mean, and what action you're appealing. And there's time limits to bring Article 78s when they can, depending upon the type of Article 78 per time. Not right now, but again, there is a challenge pending. I think the board should be aware of that. That there is the lawsuit that Rhinebeck is a party to, that Common Sensus is a party to, that is against the town of Clinton, the town of Hyde Park, CECNY, amongst others. That's pending before Judge Hayes, that's true.
Is there any avenue for a challenge outside of the idea of an Article 78?
In the likely avenue would be in Article 78, but there's many legal minds that might think of different avenues for that, but that would be, I would assume the likely challenge would be in Article 78, yes.
Any other questions? for Shane?
I would just say that with what you just described, would agree that, during that time, it was specific to the non-appealable, not just a very, very broad term of any type of challenge or objection at large. Any other comments or?
Shane, it's a little off topic, but the comments from Wendy Maitland about Hyde Park adopting local law 1, not only because of the situation, this specific situation, but other situations involving the town and then adjacent townships and whatnot, doesn't that sort of undermine the validity of the challenge? It seems retaliatory if there are other.
Yeah, I don't want to speak, I don't want to comment on that, I don't know. And I don't feel comfortable commenting on that.
Okay.
Yeah. Yeah.
I understand.
That's, you might have a point there, but I'm not gonna, I don't think it's
I mean,
appropriate.
it was presented as if this was solely for the purpose of Six Senses, when in fact, you know, if her information is true, there are other similar situations, not only with the town of Clinton, but other adjacent townships.
I think what this board needs to focus on is our town code.
Yeah, I said it's off topic, but.
Yeah, no, I understand. I just think it's, that you have a so ordered stipulation that has been served with notice of entry. You know, and that, one of the reasons for that, so ordered stipulation is that Hyde Park local law. That's true. That was the origin of the, reversal of those very specific things that, those very specific zoning administrator opinions in Hyde Park. So, but, you know, it's not our job to interpret that Hyde Park local law. You have a so ordered stipulation of settlement that the town of Hyde Park is telling you that those underlying decisions, which were referenced in your June 4th decision, have in fact been reversed. You have that.
Yeah, that's the issue at hand.
Yeah.
Okay, thank you.
But again, it's what was intended by the board. It's not, you know, by those terms. So that's the decision of the board to make, what the intent was.
Perfect. Oh, good, thank you. Gives us a lot to think about and continue to mull over.
And read.
Somebody's got to move that picture one board down so it lines up with everything.
Maybe Victoria would.
All right.
Those lines in that blind have to be moved to the center.
Got a good eye, Judge. Good eye.
Yeah. Any further discussion about this? All right, great. Thank you very much.
So we're adjourned until the 18th? Is that the plan? The 18th? Or?
Yeah, do we have anything else to do tonight? Okay, all right. Second, do we have a second? All in favor? All right, we are adjourned.
I was told by somebody once, motion to adjourn only once every second and there's no vote. In the meeting, you just need two people who get tired of the meeting.
If I do that, we could have been done 2 hours ago. Yeah. We could do that in the middle of it. Okay, I make a motion to adjourn the meeting. Did Robert's rule, is that really in there? I remember reading that book, I don't remember that. That would be an important thing for me to take it out.
The men's room over the road.
Bye. Good night.
Okay, bye, everybody.
All right, careful driving.
Thank you.